So once again, a welcome to our distinguished guest, Justice Ginsburg, and to another distinguished guest, one of ours, Ruth Rubio Marín. On occasions like this, in recent years, I've taken to saying, you don't need an introduction because we all have Google, and you can go on Google and find everything you want to know. But in this case, we don't even need Google. So therefore, allow me, Justice Ginsburg, and also our own, if I can be just for 2 minutes personal. It's not the first time that I welcome you in Florence. Can you put the picture up, please? This was 13 years ago. It was a special occasion. I was told that it was the first time that there were 5 justices of the Supreme Court in the same room, other than in the Supreme Court itself, outside the United States. And the little girl you see there is one of my daughters. And you know that we say that Ruth Bader Ginsburg has had an impact on many generations. And the reason I'm putting this photo up is she was a 7-year-old girl at that time. And maybe the touch of your hands, she's now a second-year student at the University of Chicago, very, very active feminist, very, very active civil libertarian. And the last time she came home, she was wearing RBG t-shirt. And it's to my great regret that I didn't take a photo so that I could have put that up. Thank you very, very much for being with us. And I'm going to give the podium now to Laura Downs. Thank you.
Thank you, Joseph. All right, welcome to all of you. Benvenuti tutte e tutti. The EY's annual Ursula Hirschmann Lecture on Women and Gender is named for the German anti-fascist activist and European federalist who in 1975 founded the Association Femmes pour l'Europe in Brussels. Born in 1913 to a middle-class Jewish family in Berlin, Ursula Hirschmann, who was an ardent member of the Socialist Youth's anti-fascist resistance movement, left Germany in 1933, first for Paris, then Italy, where politics plus the ties of marriage connected her to a group of like-minded activists and philosophers in Trieste. Some, soon they were all engaged in clandestine anti-fascist activity and had a number of hair-raising adventures, some of them tragic, during the years of war and occupation. Now, in the interest of brevity, I will spare you the details. Suffice it to say that in Ursula Hirschmann, our lecture series has found a worthy namesake. Before I pass the floor to Stefan Ozella, I would like to give a word of thanks, first of all, to Bridget Laffen, who is the director of the Robert Schuman Center. Without Bridget's farsighted and unremitting generosity, this lecture series would never have seen the light of day. So thank you, Bridget. I would also like to thank Rosella Corridori and Francesca Parenti for the impeccable organization of these past few days. If it had been left to me, we would be eating at McDonald's tonight. So thank you, Francesca and Rosella, for saving us from a fate worse than death. And finally, I'd like to thank Justice Ruth Bader Ginsburg for having undertaken the long and hopefully not too hair-raising journey from New York to come to Florence and speak to us today. Thank you, Justice Ginsburg.
Hello, everybody. I'm a bit nervous, so you will forgive me. It is a great honor for me to be here today to open the Ursula Hirschmann Lecture, particularly because this year we have such a distinguished guest, Ruth Bader Ginsburg, from the Supreme Court of the United States. I am all sure that we all know who Justice Ginsburg is and what she has done. Her work is of seminal importance for many disciplines, and particularly for many areas of the law. The constitutional lawyer, the comparative lawyer, and the human rights lawyer must all, to a greater or lesser degree, keep their eyes open on her scholarship and jurisprudence. Her popularity, as Professor Wilder said before, now spreads well beyond law firms, universities, and law schools. As Notorious RBG, the popular book about her life and times, makes clear, she has become something of a public idol, particularly among a new generation of young women and men in search of uncompromising feminist inspiration. Her portrait can be found on mugs, t-shirts, and even on tattoos, according to the book. She's an icon for equal rights, and she continued to inspire activists, lawyers, researchers, and all those who are, for one reason or another, interested in promoting equality. Throughout her life, she has been many times the first one, or among the first ones, and, happily for us, she managed to achieve great results, even though, as she says, she had 3 strikes against her. 1, she is a woman, in a world which is male-dominated. 2, she is Jewish, in a world where anti-Semitism is still a sad reality. And 3, she is a mother, in a world where mothers are even more firmly excluded from the job market. So she went to law school, first to Harvard, and then she transferred and graduated from Columbia, at a time where women were still a rare sight in law schools. There she felt that everyone's eyes were on her, and she was asked by faculty members, if I'm not mistaken, how she justified taking the place of a man. Then she became a very well-known and widely respected litigator, the head of the Women's Rights Project at the American Civil Liberties Union, even though, when she was fresh from law schools, law firms refused to hire her. Being an attorney was, indeed, and again, something that only men could basically do. She brought cases to tackle gender discrimination when the Equal Protection Clause was still interpreted as referring only to race. She lodged, discussed, and won the first ever case on women's discrimination in front of the Supreme Court, Reed versus Reed, which in fact was not decided much time ago, just 40 years ago. She was a law professor, first at Rutgers Law School in Newark, and then at Columbia Law School in New York City, in the 60s and the 70s, when teaching law, again, and indeed, was something that only men could do. And nevertheless, she did it. And from this position, she managed to teach progressive and cutting-edge courses, such as those Women and the Law. She has been among the very few women judges in the federal judiciary, where she served as a federal appeal court judge in DC since the beginning of the 80s. In 1993, she reached what, not many years before, would have been unimaginable, and she has been appointed by President Clinton to the bench of the Supreme Court of the United States, only the second woman ever. Throughout her whole career, she has contributed immensely to raising awareness about the need for equality between genders, and in particular, to rebutting gender stereotypes, those undemonstrated general assumptions that so often motivate differential treatment and hinder the full development of human potential. She understood, before many others, that sex discrimination affects not only women, but also men. And on a personal note, I may also say that sex discrimination and sex stereotypes affect also those who do not identify as either men or women. She's known to be a tenacious and tireless worker, also according to the book, and she managed to get by with 1 or 2 hours of sleep per night at the beginning of her career. And this is pretty amazing for me especially. She even managed to never fail to do her daily push-ups. I'm sure we are all impatient to hear Justice Ginsburg herself, so I will stop here. Just before I do, however, I want to stress that as a litigator, as a professor, and as an appellate judge, of course, as a Supreme Court justice, she has been the key person in advancing rights and values which are now considered the very core of constitutionalism and which affect the all of us, men, women, heterosexual, and homosexual persons. Her work is central in the still ongoing struggle for equality, and her figure remains an example and a source of inspiration for those of us who are walking or about to walk that path. Also now, a word for my supervisor, Ruth Rubio Marín. She is professor of comparative constitutional law here at the Institute, and she shares many aspects, I would say, with Justice Ginsburg. She is also a passionate lawyer. She is also a tireless worker. I have mails like at strange hours at night, so I can testify that. And finally, she is also an ardent feminist. So now I must say, ladies and gentlemen, an applause for Justice Ginsburg and Ruth Rubio Marín.
May I take him with me whenever I need an introduction? That was beautifully done, and I thank you very much.
So good afternoon, dear researchers and dear colleagues and dear guests. It is a really beautiful honor to have such an extraordinary person as a guest for this annual Ursula Hirschmann lecture. Now, when invited 2 years ago, because she's tough to get, believe me, she did tell me she preferred a dialogue, a conversation, an interview, but not a formal lecture, which I think was a brilliant suggestion, because it does allow us to tackle her whole persona without making rigid divides between the personal and the professional, as a good feminist, I would say. So, and I think this is something particularly important for our researchers, who I want to be the main protagonists of this event, as they face in the years to come the question of how to juggle the ambitious professional careers that I'm sure most of them want to have with fulfilling personal lives. So before I proceed with the dialogue or the interview, I want to mention two rules. The big Ruth rule and the small Ruth rule. The big Ruth rule is Justice Ginsburg prefers not to be asked about cases that are pending or about or likely to come up, but doesn't mind answering about anything else that she's written about in her capacity as a professor or a judge. And the small Ruth rule is when I'm done with the interview, we will have a question and answers session, and I will really encourage the researchers to take the floor and guide that conversation, as opposed to my colleagues. So maybe picking up from something Stefano said, the notorious RGB phenomenon. So Justice Ginsburg, how does it feel to become at this stage in her life this character, this t-shirt, fingernails, mutts image? And what do you think it is an expression of?
In the words that the current generation uses, it's awesome. It's quite unbelievable that at age nearly 83, everyone wants to take a photograph with me. The book is the result of a second-year student at NYU Law School being very upset by a decision the Supreme Court had just rendered. The case is known as Shelby County, and the majority in that case essentially put an end to the Voting Rights Act of 1965, which was a major piece of civil rights legislation designed to make sure that African Americans would not be deprived of the franchise. She was angry, but she decided that anger is not a useful emotion. Instead, she wanted to do something positive. So she created a Tumblr, and it started with my dissenting opinion in the Shelby County case. And it took off from there. Now, why is the younger generation interested in an octogenarian? Well, one thing that the Shelby County dissent illustrated is that one can disagree without being disagreeable, And one can be effective not by using invectives, but by using reason. So that's how the Notorious RBG began. The name comes from a well-known rapper, Notorious B.I.G. And when I was told this, I said, well, we two have something in common. Both the rapper and I were born and bred in Brooklyn, New York. And as for the mugs and the t-shirts, that is fine, but the tattoo, and that is a bit much.
So when you attended law school, the world was different from the world our researchers and our female researchers are living in. Can you tell us a little bit more about the world back then when you were a young woman and a young mother, with ambitions for your professional career, so that we can set the rest of the conversation into perspective?
I entered law school in 1956, Harvard Law School. Harvard Law School did not admit women until 1950-51. And I think Stefano referred to the famous dinner that the dean of the law school held for all of the women, all 9 of us, in a class of over 500. And he asked each of us in turn to explain why we were at the Harvard Law School occupying a seat that could be held by a man. Years later, I came to know the dean quite well and understood that this was a man who didn't have a sense of humor, and he didn't ask the question to wound. But it was 1956, first class was 50-51. There were still doubting Thomases on his faculty who thought it was not wise to admit women. So he wanted to be armed with stories from the women themselves about what they would do with their law degree. There were 9 of us. The class was divided into 4 groups, so there were 2, at most 3, in any one section. We felt a special obligation. That is, if we were called on in class, we were representing all women, and if we gave a dumb answer, the response would be, well, what would you expect of a woman? So we were all well prepared. The difference between the 50s and the 70s was well expressed by a colleague of mine at Columbia Law School. By the time I got to Columbia, women were over 25% of the law students. Today, they're about 50%. He said he had a certain longing for the old days. When the class was moving slowly and you wanted to get a crisp right answer, you would call on the woman. She was always prepared. You'd get the answer you want and proceed with the class. Nowadays, he said, there's no difference. The women are as unprepared as the men. Well, in the 50s, there was no anti-discrimination in employment litigation, so employers would put up sign-up sheets for students to interview, and more often than not, it would say men only. Not much had changed by the time I started teaching. My first class at Rutgers Law School had 100 students, 3 were women, so women were about 3%. of the law students. The change in the law school world has been enormous. Perhaps I can illustrate it best by pointing out that my dear current colleague, Elena Kagan, was the dean of the Harvard Law School, and when she left to become the Solicitor General of the United States, she was succeeded by another woman, Martha Minow. In a university that was once all male and now has a woman as president of Harvard University. So I have seen in my lifetime enormous changes.
So maybe taking the trip to today and referring to another eminent woman that I'm sure you know of, Professor Anne-Marie Slaughter, Professor of Politics and International Affairs, Princeton University. Anne-Marie Slaughter wrote a rather controversial but very, very widely traveled and read piece at Atlantic Magazine. She's then been writing more about it. This piece was called "Why Women Can't Still Have It All." And in fact, in spite of the negative sounding title, I really recommend you to read it. It's full of good advice, especially for women who want to, as to how to navigate the demands of family life and professional life. Anyway, this piece was written by Professor Slaughter as she was stepping down from 2 years of service between 2009 and 2011 after being the first woman director of policy planning for the United States State of Department. And she found it impossible. After 2 years in Washington, she returned to Princeton. She had simply found it impossible to juggle the demands of 2 teenage boys and the job that she had to do, in spite of the fact that the primary caretaker during those 2 years had been her husband, also a Princeton professor. So she wrote this article because she felt there was an obligation on the part of successful women to actually point to the fact that in spite of the fact that a few women, a few heroines, a few super women like yourself, and she cites you in the piece, you were an inspiration to her like you have been an inspiration to many. In spite of a few, she says, going around, especially if you are a successful woman, and saying that women can have it all, and denying the statistics that say that most women still in today's America can't have it all, actually doesn't do any good, because it conveys to women the message that it's their fault if they just put that extra effort. And it avoids a conversation about the structural changes that actually need to take place for most women to be able to have it, to have more, to have a balanced work and family life. So let me ask you, can women have it all? And if most women can't, is it good to go around saying or telling women that women can have it all?
At first, Anne-Marie Slaughter's article is now a book. She expanded it to book length. There's another book of advice about how to be a professional and a parent, and it's written by a woman who's a law professor at Yale, Amy Chu, and it's called Tiger Mom. I was a bit surprised that Anne-Marie Slaughter said, "Oh, women can't have it all." I don't know anyone, man or woman, who has it all. And I can say that in my relatively long life, I have had it all, but not at one time. So, for example, in the years when my husband was a young lawyer and he was determined to become a partner in a New York law firm within 5 years, during that time, I took primary responsibility for my then one child. and the household. When the women's movement came alive in the late 60s, and I co-founded the ACLU Women's Rights Project, my husband realized that I was doing something that was more important than the tax problems he was solving for big corporations and rich individuals. So it was natural for there to be a shift. And I must say my daughter was a big help in getting me out of the kitchen. Because my routine was I'd come back from teaching, I took out the one cookbook that I had. It was called The 60-Minute Chef. It was nothing took longer than 1 hour from when you walked in the door till it was on the table. My husband was a master chef. And my daughter in her high school years noticed the difference between mommy's cooking and daddy's cooking, and decided mommy should be phased out of the kitchen. As I was, and from 1980 till today, I have not cooked a meal. Well, how can I do that when, sadly, my husband died 6 years ago? My food-loving daughter comes once a month to cook for me. She fills the freezer with food, and then we do something nice together in the evening. She goes back to Columbia Law School where she teaches. So it's very nice that I have her with me once a month, and she is a very good cook, almost as good as her father. So in Anne-Marie Slaughter's own case, she described a son as being a bit of a problem. He wasn't doing well in school. I had a son he was called lively by his teachers. I called him lively. They called him hyperactive. And Anne-Marie Slaughter describes it when she goes back to Princeton. Now, she doesn't just go back to Princeton and then do part-time work. She's head of the Woodrow Wilson School. She's going all over the country giving lectures. And yet she describes this child as suddenly improving. In real life, that doesn't happen. My son, who is today a grand human, there was no quick change in his behavior in his high school years. It took quite a long time. So I am a little suspicious about the notion that her presence in Princeton resulted in a transformation in this child's life. But the main thing I'd like to convey is that for all of us, we will not have it all at one time. And I think I've been blessed by the course of my life. If you have a life's partner, then it's a balance between the two of you. Sometimes one helps the other, and then sometimes it shifts. When I got my first good job in Washington, D.C. in 1980, thanks to President Jimmy Carter, people asked me, isn't it difficult to commute from New York to Washington, D.C.? And I said, why do you think I'm commuting? The assumption was that my husband, a partner in a New York law firm, would remain in New York. But he didn't remain in New York. We moved together to Washington, D.C., and he became a distinguished professor of tax law at Georgetown University Law Center. In that time, it was still unusual to have women in the federal judiciary. We would go to social functions, and when then Judge Ginsburg was introduced, more often than not, the hand would go out to shake my husband's hand, and he would politely explain that I was Judge Ginsburg. That doesn't happen now with
You are known to have said that choosing the right life partner is probably one of the wisest career decisions that women make. In fact, and your husband Marty, with whom you shared, I think, 56 years of a beautiful marriage, also, in spite of his own successful career as a tax lawyer, did say that the most important professional thing he had done was to support you, which is quite extraordinary. How was it for him as a man to be, in the role that was traditionally fulfilled by the wives of the justices of Supreme Court? What does it take for a man to be able to do that?
Total confidence in his own ability. In the days when we were very young, we met when I was 17 and he was 18. He was the only boy I knew up till that time who cared that I had a brain. And I think Marty's attitude was, I must be pretty good, because he decided he wanted to spend the rest of his life with me. When we went to law school, he boasted that his wife was going to be on the law review. And some of his classmates said, we looked at you in this little thing, and your husband is boasting that you're going to be on the law review. And as it turned out, I was. He always made me feel that I could do whatever it was. I was truly blessed. I'll tell you one story about our life together. So I mentioned this lively son. When he was in grade school, I would get a call, at least once a month, to please come to see the school principal or the room teacher or the school psychologist to tell me about my son's misadventure. One day, I was at my office at Columbia and I was weary. I'd stayed up all night writing a brief. I said to the school principal, this child has 2 parents. Please alternate calls. And it's his father's turn. So Marty went down to see the school principal. He was told, what had my son done? He stole the elevator. It was a handheld elevator. The operator had gone out to have a cigarette, and one of my son's classmates dared him to take the kindergartners from the ground floor to the top floor. When he got to the top floor, he was met by the headmaster. So my husband's response to this news that my son had stolen the elevator, how far could he take it? Well, either Marty's sense of humor or the fact that he was a man and they would have to alternate calls. I saw no quick change in my son's behavior, but the calls came barely once a semester, because there was much more reluctance to take a man away from his work than to call a woman to account for the misbehavior of her child.
So, you were blessed to find a supportive partner. Not everyone is, and not everyone was at that time either. But many of us certainly do think, and I'm sure you agree, that that is not enough. That ultimately we should aspire to have a society, a community, a state that takes its due responsibility in enabling a reproduction and a care-friendly society. In your writing and in your thinking, you have been very careful to stress the idea that in order to achieve that, it is not a good way to give, extra accommodations for working women, because these extra accommodations can backfire. They can, in fact, stigmatize women, make employers hire less women. And so you have preferred gender-neutral solutions. Just to give you a concrete example, in the US, for those of you who don't know this, under the Medical and Family Leave Act of 1993, any employee can take up to 12 weeks of unpaid leave to either take care of a newborn or a sick family member, or themselves if they are sick. And precisely because it's formulated in a gender-neutral way, was upheld by the Supreme Court. Now, in Europe, many of us tend to think, well, is this the way, to go? Should we be assimilating having a child with being sick? The leave is unpaid, so that is unfortunate, really. It stigmatizes or pathologizes pregnancy, one could say, and child rearing. So in Europe, as you know, we have the 14 weeks of paid maternity. Some of that is actually compulsory leave. It's a very different solution. It is a solution that is perceived as enabling equal opportunities to women, though I see that there is the risk that you say, i.e., it is accommodating working women. It does not subvert gender stereotypes and gender roles. And in fact, in Europe, we do have the problem of many more women working part-time when it comes to mothering than men do. So my question to you is, can we maybe think of a third way? Can we think of a way that grants pregnancy and parenting specific recognition and accommodation, thereby raising its social and societal value, without at the same time, stereotyping or entrenching gender stereotypes? Europe is barely starting to experiment with some formulas. Father's leaves, still very short, mostly non-mandatory, but we could go down that path. Parental leaves with incentives for fathers to get more involved. Do you see a third way between what the US has done so far and what Europe has done so far?
You've asked a question that has many subparts. Perhaps I should say first what the background is of social legislation. Social legislation has been common in Europe for a long time, since Bismarck. In the United States, the attitude was fierce individualism. We don't need the state to help. If you have the opportunity and you're ready to work hard, you don't need government to help you. And we didn't get Social Security in the United States until the 1930s. And the official title of our Social Security law is the Federal Insurance Contributions Act, insurance contributions. So it was sold to the public, not as social welfare legislation, but as an earned right. As you work and you get insurance, and as a result of your contributions. So the United States has been quite different. The experience has been quite different with regard to social welfare programs. The second is, I'm sometimes puzzled when people say, well, you're an assimilationist as opposed to accommodationist. I would say I was a pragmatist. I was dealing with the art of the possible. When I began litigating gender discrimination cases, the law books, federal and state, were riddled with gender-based differentials. The overall picture was of separate spheres. Separate spheres. The work sphere is for men, the home is for the woman. If the woman works, she's just a pin money earner. That separate spheres notion was harmful to women. And our effort was to break that down. No more separate spheres. And it went for men as well as women. When I think of a popular magazine in the 70s for girls and young women was Ms. Magazine. They put out a record for children. And the first song was Free to Be You and Me. Whatever is your God-given talent, you should be able to pursue it. You shouldn't be held back by artificial barriers. And the next song was William Has a Doll. So it was okay for William to have a doll that he liked to care for. That's what we were trying to do, to break down the separate spheres mentality. Now, I do think the Family Medical Leave Act, which is in the 1990s, it really was written with the woman worker in mind. That is, what does the woman worker need? She needs to be protected against being fired, losing her job. If she has to stay home to care for a sick spouse, a sick child, a sick parent, if she herself is sick. Now, it had many shortcomings. Number one, the leave was unpaid, but at least it was a beginning. So I see the Family Medical Leave Act as a woman worker-centered act, not a woman trying to get into a law that was designed for the male worker. Quite different from the Social Security cases that I was litigating, where men, if they died, there were benefits for their wives. But if a woman worker died, there was nothing for the male who was her spouse. And of all the cases that I litigated in the 70s, my favorite was Stephen Weisenfeld's case. This was a man whose wife was the principal earner in their family. He was the main homebody. She had a healthy pregnancy. She was teaching math and until the 9th month. She went to the hospital to give birth. And the doctor tells Stephen Weisenfeld, you have a healthy baby boy, but your wife died of an embolism. He was determined that he would work only part-time till his child was in school full-time. So he went to the Social Security office to register for what he thought were child-in-care benefits, and was told those benefits are available only to a woman. And this young man wrote a letter to the editor, to his local newspaper, and it said, I've been hearing a lot about women's lib. Let me tell you my experience. And the tagline was, does Gloria Steinem, a great feminist in the United States, does Gloria Steinem know about this? It happened that a woman who was teaching in the Spanish department at Rutgers, lived in the same town, read the letter to the editor, and she said, this isn't right, is it? I suggested that Stephen Weisenfeld contact the New Jersey affiliate of the American Civil Liberties Union. And that's his case, went to the Supreme Court. There was a unanimous judgment in his favor. The majority thought it was discrimination against the woman as wage earner because her work didn't get for her family the same benefits that a man's work would get. A couple of them thought it was discrimination against the man as parent because he wouldn't have the opportunity to personally raise his child. And one, who later became my Chief Justice, he was then Justice Rehnquist, said, this is totally arbitrary from the point of view of the baby. Why should the baby have the opportunity for the care, personal care of a parent only if the parent is female. But it was an example of how these separate spheres hurt everyone, the woman worker, the male as parent, and the child. But, so that's what we were about, to stop pigeonholing people because they were women or because they were men. And in that respect, I'd like to tell you about a case decided with an opinion by Justice O'Connor, her very first year on the bench. And it's called Hogan v. Mississippi University for Women. This was a young man who wanted to go to what was the best nursing school in his area, but it was Mississippi University for Women. When his case got to the Supreme Court, some of the justices said, well, this is kind of an affirmative action program for women, reserving the nursing school for women. Justice O'Connor, who grew up as a woman, and who, by the way, how did she get her first job in the law? She was a top graduate from Stanford Law School. No attorney in the state of California would hire her to be a lawyer, to be a secretary. Yes, not a lawyer. So she went to a county attorney and she said, I'm going to work for you for free for 4 months. And then you decide if my work is valuable enough to put me on the payroll. That's what life was like for women in the 50s. So Justice O'Connor understood that there could be no better thing for women in the nursing profession than to get men into that profession in numbers. Because when a field is dominantly women, it tends to be low pay. You get men to do the same job, the pay rate tends to go up. So she understood that this was no affirmative action for women, that women would be well served if nursing schools were open to men, and the more men that chose that profession, the better off women would be.
Let me maybe talk now about something on which also American and European constitutionalism differ, which is abortion. Now, what is interesting about the way abortion constitutionalism evolved is that in the 70s, both in Europe and in the United States, is exactly when we saw courts stepping in vis-a-vis the legislature in deciding what was possible or not in terms of legislating in this domain. But the starting positions were radically different. In Europe, to the extent that constitutional courts took on the question, and the best example of this is the German Bundesverfassungsgericht abortion decision, the first one. The idea was that the starting point in the constitutional reasoning was the life of the unborn. Right? That was the key piece of the constitutional construction. And that was translated almost automatically into a duty of motherhood for pregnant women, constitutionally speaking. Now, of course, you know that the US Supreme Court started from a very different perspective when in Roe versus Wade, it decided that women with their doctors, had a privacy-based right to decide whether or not to carry through with a pregnancy within a trimester framework. So for Europeans and for European feminists, Roe v. Wade has always stood as a symbol of the utmost recognition of women's reproductive autonomy. Now, you yourself have been very critical, actually, of Roe versus Wade. And I was wondering whether you could share with us why you were so unconvinced by this decision.
not by the judgment. The judgment was, in my mind, absolutely right. Well, you know, the United States is a federal union, and abortion law was state law, not federal law. And the states were all over the lot. Some states, like my home state in New York, a woman could have an abortion in the first trimester if she wanted it. Other states had grounds, including if bearing the child would place the woman's health at risk, or if there was a danger of a deformed fetus. And then there was Texas. Texas allowed abortion only if it was necessary to save the woman's life. Her health could be devastated, it didn't matter. It was the most extreme law in the nation, and the court easily could have said, this most extreme law is unconstitutional. Instead, it wrote a sweeping opinion that made every law in the country, even the most liberal, unconstitutional in one fell swoop. The opinion is as much about the doctor's right to practice medicine as he sees fit, as it is about a woman's right to control her life's destiny. My notion was that if the Supreme Court had simply struck down that most extreme law, then the usual political process would work. There would be some reaction to it in the states. There'd be more change, there'd be more challenges. The next challenge might be to a state that had very restrictive rules about you have to have the advice and consent of 2 doctors. You have to have it performed in a hospital. The progression that I saw would be that there'd be step by step a series of decisions. Instead, what happened was there was this decision that did it all, and the people who opposed women's access to abortion had an organizing tool better than anything they had before. I mean, there was a strong anti-abortion movement before Roe v. Wade, but it accelerated, I think, as a result of that decision, because now those forces had one target to aim at. The decision in Roe v. Wade made by an undemocratic institution, 9 lifetime appointees. Every year, in fact, shortly before I came here, there is a March for Life on the anniversary of Roe v. Wade. So, as I said, I think the judgment striking down the Texas law was absolutely right. But I don't think the court's opinion was satisfactory for a number of reasons. One is, it wasn't really privacy. It's not that the woman doesn't want anybody to know. It's autonomy. It's her right to decide what her life's course would be. So I saw Roe v. Wade, or the abortion issue, more in terms of women's chances for full equality instead of a privacy issue. Now, we continue to have abortion business in this very term. We will have, when I go back on our February calendar, the state of Texas had 40 clinics that offered contraceptives and abortion services. That number has shrunk to 6. Why? Because Texas passed a law saying any facility offering abortion has to be a full have all the equipment of a full surgical center, and the doctors have to have privileges at a hospital within 30 miles of the clinic. Those laws have been challenged, and they will be argued at the end of February.
So one of the things I hear you saying in response is too much, too fast, right? And I wonder whether some voices or some concerns along similar lines could be raised vis-a-vis the Obergefell equal marriage, same-sex marriage decision. In essence, I would like to ask you, when does a judge feel and know when it is the right time to act? And is it the role of a judge to reflect or to change values that are socially dominant?
The judiciary is a reactive institution. Judges don't decide that this is the year we're going to end segregation in school, or this is the year that we're going to take care of abortion. We are reactive to the cases that are brought before us. Let's take one of the most famous cases the court ever decided, Brown against Board. So some people think that that was a bold step that the court has taken to essentially end apartheid in America. But preceding Brown v. Board, there was the Second World War. It was a war against odious racism. And yet our own troops in that war were segregated. It wasn't until the very end of the war that they began to be integrated troop units. When Brown v. Board came to the court, there was a brief on behalf of the United States, and essentially this is what it said. Court, the United States is being embarrassed all over the world because the Soviet Union is constantly talking about the racism that exists in the United States. So please, court, let's put an end to this so the Soviet Union won't be able to say to other countries, don't look at the United States as a model. They are a racist society. That was the United States government telling the court, please end law enforced separation of the races in schools. So it wasn't all that hard for the court to make the decision when it did. But what I said about Roe v. Wade, it has a relationship to Brown v. Board, too. A great lawyer, Thurgood Marshall, who later became a Supreme Court justice, he was the legal director of the NAACP. And he argued cases in the 40s, telling courts, I am not arguing in this case that separate can't be equal. These schools are vastly unequal. And to take one case from the 40s, when Texas got the message that you couldn't deny legal education to African Americans, what did they do? They set up a separate law school that would be just for African Americans, vastly inferior in facilities, and very important part of doing well in the law. You have classmates, there are alums who will help you in the job market. There was none of that for this school. That case was argued to the Supreme Court, not that separate can't be equal, but these facilities are unequal. And then there were cases involving universities of the same order. Thurgood Marshall was not willing to go for separate can't be equal till he had those building blocks in place. There has been, I think, an enormous change in the United States in the attitude to gay and lesbian and transgender people, and it's generational. It's not an issue for the young people, at least the ones that I know, it's just not an issue at all. If you love someone and want to marry that person, it should not matter whether it's the same sex or the opposite sex. I think what happened in the United States is people who were gay and lesbian stopped hiding in the closet. There was one Supreme Court justice, Justice Powell, commented that he had never had a gay law clerk. Well, in truth, he had had a number, but they were still in the closet. When people stood up and said, "This is who I am," and others looked around, "Who is that?" "It's my child's best friend. It's my colleague." It's a change. It's unlike the race problem, because we still have a high degree of segregation in living, neighborhoods that are dominantly one race or another. So there's still that separation, but that wasn't true. I can give my first Chief Justice as an example. In the 1970s, if you had asked then Justice Rehnquist a question about fair treatment for gay and lesbian people, he would tune out. But by the 90s, he had hired as his assistant a woman whose partner was another woman, and together they were raising 2 children. And she came to court functions. That attitude change, it happened very swiftly, but what it took was people willing to say, "This is who I am, and it's okay."
Time was right.
So even, there have been a notorious clerk in Kentucky who wouldn't give out marriage licenses, but for the most part, there has been not much fuss at all about the Obergefell decision.
Justice Ginsburg, when asked, when will there be enough women at the Supreme Court of the United States, you're known to answer, when there will be 9 of us, which I think is brilliant. And you, I think, reasonably described that for the longest time. It was a male-only bench, and no one seemed to have any, concern about its legitimacy. And you described your feeling when Justice O'Connor retired as one of loneliness, and you have celebrated clearly Justice Kagan and Sotomayor joining the court and now sitting all over the bench, reflecting seniority. So can you tell us a little bit more about why exactly do you think it is important to have women sitting at the court? Is it that they bring in different experiences? Is it that having women sitting on the table generate different dynamics, even around the way affairs are discussed? Is it the importance of role models for younger generation? What is it?
All of the above. But I'd say first is the public perception. When Justice O'Connor left the court, and I was a lone woman, when we went through the curtains onto the bench, the public would see a small woman and 8 basically well-fed men. It was altogether wrong. Now, because I've been there so long, I sit toward the middle. On one end is Justice Kagan, the other end, Justice Sotomayor. The school children parade in and out of the court. They're on a 10-minute line. And when they come into the court and they see, well, that's, women, we're 1/3 of the bench. We're no longer one at a time curiosities. And if you came to an argument at the court, you would see that my newest colleagues are not shrinking violets. They're very active in the colloquy that goes on at oral argument. In fact, there's a competition between Justice Sotomayor and Justice Scalia, who can ask the most questions at an oral argument. Does it make a difference on some issues? Well, we all come to our jobs with whatever upbringing we had and who we are. So growing up female, not the same as growing up male. I can think of one case where my colleagues were educated during the oral argument itself. It was a case about a 13-year-old girl who had been strip searched because she was reported to have had pills in school. Well, the pills, these were not narcotics. There was an Advil and another similar drug. So she was carted off to the girls' room and strip searched. Her mother was outraged and brought us a case against the school district for exposing her daughter to that humiliation. At the oral argument, there were comments about, well, the boys, they change in the locker room, and there's nudity there, and nobody thinks it's a problem. And I said from the bench, a 13-year-old girl is not like a 13-year-old boy in that regard. She's very self-conscious about her body, and it can be hugely embarrassed by what happened to her. Then the jokes stopped. Nobody was talking about the boys in the locker room anymore. Everybody took it seriously. But they stopped to think about it, about the difference. Some of them had daughters, so they knew that. There have been, other incidents. The Supreme Court has a rule about proper attire for people who are in the front, including the reporters. The bench is up here, and on this side, the reporters from the various media. One day, the reporter from the New York Times, who was then Linda Greenhouse, brought a new editor to sit with her in the first row of the reporters section. One of our police officers, who happened to be a woman, told the editor, "You can't sit there, we have a no t-shirt rule." Well, this editor was wearing an Anne Klein ensemble. But the top looked to the police officer as a t-shirt. So Justice O'Connor and I decided we've got to take our police officers out of the business of being the arbiter of women's fashion. We had a public information officer, who was a woman, who knew the difference between an Anne Klein ensemble and a t-shirt. Next problem, a woman well known for a column giving advice to the loved one. Dear Abby is the column. Dear Abby gets a letter from a woman who came to the Supreme Court to watch argument. She said they came early because they wanted to make sure they would be seated. They had breakfast in the cafeteria. He left to use the facilities. He came back and she said, "Well, that's a good idea. Before we go into the court, I'll stop at the restroom too." And she was told by the police officer. I'm sorry, but the women's restroom doesn't open till 9 o'clock. So dear Abby sent this letter that she had received to Justice O'Connor and to me, and she said, is this so? We said it couldn't be, but in fact it was. The rule was made in the days when very few women showed up at the Supreme Court. Of course, the next day, there was no longer a 9 o'clock opening for the women's bathroom. But we have had states, the state of Minnesota has, on its highest court, on its Supreme Court, there was a bench for a time of 5 women. That was it. Every member was a woman. Our court is not quite doing quite as well as the Supreme Court of Canada, that has 4 women, including its Chief Justice. But I think that women in numbers are there to stay, not just on the federal bench, and not just on the Supreme Court bench, but in state and federal courts across the country. The change came when I was appointed. It came in the late 70s. We had a president, Jimmy Carter, who was not a lawyer, but cared about the justice system. He looked at the federal bench and observed, those guys all look just like me. But that's not how the great United States looks. So he was determined to appoint women and members of minority groups in numbers. And although he had only 4 years in office and no Supreme Court vacancy to fill, he literally changed the face of the U.S. judiciary. He appointed over 25 women to federal trial courts, 11 to courts of appeals, and I was one of the lucky 11. Then President Reagan didn't want to be outdone and was determined to put the first woman on the Supreme Court. So it's an enormous change where you see women. I went to law school, and there was never a woman teacher. I had gone to a university, Cornell University, where there was a 4-to-1 ratio, 4 men to every woman. The excuse that was given for the ratio was that the women had to live in dormitories. The men could find places in college town to stay. They didn't have to stay in the dormitory. I get to the Harvard Law School. By then I'm married and have a child, so it didn't affect me. But there's no room in the dorm for women. The dormitories were reserved for men. The women have to find a place in town. There was no rhyme or reason for that. So you can see why I am exhilarated about all the changes that have occurred in my lifetime. Yes, we have not reached nirvana, but maybe I can refer to my granddaughter, who is now a second-year law student. When she was 8, she was with me and I was being filmed for something or other. And this 8-year-old said, I'd like to be in the film too. So the director said, all right, Clara, I'll ask you a question. What would you like to be when you grow up? And this child answered, I would like to be president of the United States of the world. This is not an aspiration that an 8-year-old would have had a generation before.
So precisely because it is so important that more and more girls can aspire to be presidents of the United States of the world. There is a worldwide movement taking place, legislating gender quotas. It's over 85 countries that have now legislation to ensure that the numbers of women in parliament, but not just in parliament. We see this gender quotas phenomenon spreading onto the executive, the judiciary, and even in Europe to positions of governance in corporate boards in companies. The United States has not gone down that road. It has not even attempted or seriously discussed to pass legislation, even though, as much as we celebrate the changes, because they are to be celebrated, it is true that women are still hugely underrepresented when it comes to Congress, the Senate, and corporate boards. So, given that you are one of the few justices who actually thinks that US justices and scholars can also learn and not only teach to the world, do you think there might be, in an ideal world, would it be interesting to consider joining the club of countries passing gender legislation that enforces these kinds of quotas? And if so, how do you think it would sit with the constitutional framing of your country?
I don't think there's any court in Europe or any place, a court, that has set quotas or parity. This has to be done by the government, and as it was in France. It has to be done through legislation. Do I think there's a chance that this Congress would pass such legislation? But let me tell you two cases. One involved the high school that my colleague Stephen Breyer attended. It was a school for gifted children. There was an admissions test, and the ones who got the top scores were admitted. Well, for a couple of years running, more girls passed than boys, and this school was concerned about that. So it had a quota system, at least 50% boys. And that was challenged by the American Civil Liberties Union as unconstitutional. The other case, I brought it with me because I knew you, Ruth, you were going to ask this question, is a case from the state of Washington. And it involved a law that says the state committee of each major political party shall consist of one committee man and one committee woman from each county, elected at the county committee's organizational meeting. It shall have a chair and a vice chair who must be of the opposite sex. That was challenged as a violation of the equal protection principle. It went to the Supreme Court of the state of Washington, and that court upheld that parity system as assuring women actual as well as theoretical equality of rights. You know, in the United States, because we have states that have all varieties of legislation, things can be tested in one state, and if they work, maybe another state will adopt it. So that's the only answer I can give you up to now. I can say with a fair degree of confidence that the Congress that we now have would never pass such a measure, but at least it was passed by a state legislature and upheld by the highest court of that state.
But it may be the case that we are not going to have soon a women president of the world, but maybe of the United States. Would there, in your
Maybe.
view, be any prospects
Yeah.
of that ever happening, or do you see this as too deeply in tension with the US constitutional culture, just the idea to have the legislator impose gender quotas?
I can't tell whether that is going to happen because when I look at our Congress, yes, we don't have the number of women we should. But when I became a justice, there were 6 women in the Senate. The women at the court and the women in the Senate meet once a year for dinner, and we alternate the host. So the first time there were just 6 of them, and now there are about 20. So it's moving in the right direction. Maybe not fast enough. 20 is far from 50, but it's a lot better than 6. We had a woman very recently was the Speaker of our House of Representatives, and now she is the minority leader. So it may turn out that it's not needed. It remains to be seen.
It remains to be seen. Okay, well, we did start late, so I think we can expand a little bit, and that would allow us to still have 25 minutes for questions from the audience, which I think would be most a wonderful opportunity for researchers to raise their own questions. I know there are microphones. Some of the researchers, Justice Ginsburg, are up there. This is a theater, and there is no criterion for the division other than whoever got later was probably sent up. But there are microphones up there, and I really want to encourage every one of you, whether you're down or up, to raise your questions. Okay, breaking the ice. Who will start?
Oh, this is wonderful. Let me tell you why I say that. My husband was a law school teacher, and when he called for a volunteer, invariably the man's hand would go up. He had a colleague who said, "Don't call on the first hand that's raised. Wait a few seconds, and then there'll be a woman who raises her hand." The idea was the guy would speak off the top of his head, a woman would think before she spoke. So I'm very glad that you will ask the first question.
Thank you. I've already introduced myself to you yesterday, but I do it again. I'm Paulina Vella, a second-year researcher here at the UI. And now we've talked quite a bit about your important role as a role model for us young women today. And I was wondering who the strong or important women were in your life, or whether you missed very important role models for yourself.
One was a fictional character. She was Nancy Drew. Nancy Drew was the dominant character in her relationship with her boyfriend, and she was a doer, unlike the usual role for the girl epitomized by the poem, "What are little girls made of? Sugar and spice and everything nice." Little boys, snails and nails and puppy dogs' tails. So Nancy Drew was not a very good, from a point of view of literature, was not. But and then there was Amelia Earhart, a woman who was an airline pilot. On the bench, I didn't know anyone, but I had the good fortune to meet the first woman who was appointed to a federal district judgeship in 1948 by President Truman. She was appointed to the U.S. District Court for the District of Columbia. Her name was Bernita Shelton Matthews. She was a woman from Mississippi. She was a suffragist. When I got to the D.C. Circuit, the Court of Appeals, she was still alive. She was well into her 90s. And she had such wonderful stories to tell about what her life was like. One was that she was going to law school at night, and she was participating in the suffrage activities, and she would be in the marches, and she would stand at the White House with her sign, "Votes for Women." If the police hassled her, she wouldn't open her mouth. She would not say a word because she didn't want to risk being arrested and then have a problem being admitted to the bar. When she took her seat on the bench, she hired only women as law clerks. Why? Because her colleagues hired no women. And I'm told that she had the best law clerks on the court. She was also responsible for getting the first African-American man admitted to the bar of the court. She was a slender, small woman. She spoke with a Southern accent. She wore a lace collar and cuffs on the bench. So people might describe her as very feminine, but this was a woman of steel. So if I had known about her, she would have been a role model for me.
Stefano.
So, thank you for this interview. It's very interesting to be here to listen to you. And just because you mentioned it before, I think this is a good time to ask you. So I was looking at the legislation for gender recognition in the United States, and many states are still requiring sterilization procedures, physical changes, massive surgeries for one person to be recognized the gender of preference. More or less, changes are happening almost everywhere in the world, but more or less it's the same in Europe. So I was wondering whether you had an opinion on this point and what this opinion may be. Thank you.
What is he
So
asking
it's
about?
the requirement of surgery before being able to legally change your sex.
Yeah.
What is your view on this? Because the U.S. still does require, many states in the U.S. still do require massive surgery in order for transgender persons. Do they
The
have any
state's
views on
required, or is this a medical procedure chosen by a person, and is the question, does
The state
he or she
requires.
have access?
The state requires, and the question is that okay?
The state requires what?
It requires, well, not always, but very often requires sterilization and a series of massive surgeries such as vaginoplasty or hysterectomy or again breast augmentation to have the gender of preference to be recognized. So to give an example, for a male to female transgender, this person should have to...
The state is requiring there be certain medical procedures followed before they will recognize.
Gender
Yeah, this is all so new. And I think one of the benefits in the United States is, you said, a state. So maybe the next state doesn't. We have an interesting case before us involving a same-sex couple married in Georgia. One of them gave birth to a child. The second one adopted that child, so the child has two parents. The couple then separated and eventually divorced in Georgia. One of them, the birth mother, moved to Alabama. Her former spouse asked the Alabama Family Court for custody, for joint custody, or at least visitation rights. And the court in Alabama said, sorry, we don't recognize the legitimacy of your adoption. That case is on our next calendar, and you will see before June how the court will decide it. But there are many new questions that will arise, including the one that you raised. I say it's a positive thing in the United States that we have all these states with different rules. And one example that I can give is the phenomenon of no-fault divorce. So in the United States, not so long ago, in most states, the only ground for divorce was adultery. And then there was the state of Nevada said, come to us, and one of you stay for 6 weeks, and we'll be glad to give you a divorce, which the other states will have to recognize. Well, in a span of 10 years, no-fault divorce took the country by storm. What Nevada did, other states copied.
Even Texas, maybe. No, for Texas, you need the Supreme Court to step in. Other question? From the heavens? Yes, I see one here.
Thank you. Thank you very much. At a similar event in the US, you expressed that one of your biggest disappointments was the outcome of the Citizens United judgment. I wonder if you still hold that view and what you think the long-term consequences of that judgment will be.
You're asking about Citizens
United, yes.
Which said that it's a violation of freedom of expression to put limits on how much corporations can spend on political campaigns. It was a 5-4 decision. I was on the dissent side. If you can read Justice John Paul Stevens' dissent, I agree with every word in it. And I believe sooner or later the court will see the error of its way and overrule that decision. It won't be tomorrow, it won't be next year, but eventually. I am confident that that will happen. You know, the Supreme Court has made some dreadful mistakes. Think of the Dred Scott decision. That's probably the most dreadful case the court ever decided. The case involved a man who took his slave into a free state. And the slave said, now I'm in the state of Missouri, it's a free state, I am free. The Supreme Court wrote a decision that went much further. It was kind of like Roe v. Wade in that respect, much further than it needed to, including saying no person brought to the United States from Africa in chains, and no descendant of such a person shall ever be a citizen of the United States. Well, a civil war overturned that decision. Separate but equal was another one. Plessy against Ferguson, which was essentially overruled. think of the Supreme Court having upheld the detention of Japanese Americans during World War II. They did it after the war was over, but they affirmed what the executive had done, a very wrong decision. It was eventually righted, and not by the court acting, but by the president issuing an apology and Congress passing a bill providing for compensation for people who had been detained or their descendants. So there was a Supreme Court justice who said, the Supreme Court is not final because it's infallible. It is infallible only because it is final. So we speak the last word. The free speech law developed in the United States after World War I, largely. And it started out with two dissenters, Justice Brandeis and Justice Holmes. Those decisions by those opinions by those dissenters are today the law of the land. I think unanimously accepted. That's why I am so glad that I have the opportunity to say I dissent when I think the court has gotten it wrong. I know a lot of systems don't have dissenting opinions. They think it shows the law as being uncertain, unstable. But I'm glad that I can speak out in dissent. And sometimes you get an immediate reaction. If it's a question of statutory interpretation rather than what the Constitution means, my favorite example is the case of a woman named Lily Ledbetter, who worked as an area manager for a Goodyear tire company, a job that was held overwhelmingly by men. So Lily had been working at the company, and one day, she was there for over a dozen years, someone put a slip in her mailbox. It had a series of numbers. The numbers were the pay that all the men who were area managers received. The most junior man, one that Lily herself had trained, was earning more than she was. So she consulted a lawyer. She brought a lawsuit under Title VII that says thou shalt not discriminate on the basis of race, national origin, religion, sex. And she won a substantial jury verdict. The case came to our court, and the majority decided she sued too late. The law, Title VII, said you must complain within 180 days of the discriminatory incident. And she's way out of time, according to the majority. My view was simple, that the discrimination that started way back was perpetuated. It was reflected in every salary check she received, so she should have 180 days from her most recent paycheck to sue. The dissent told a story familiar to any woman, that if you're the first one doing a job that up until then has been done by a man, you don't want to be seen as a complainer, you don't want to rock the boat. If she had sued early on, no doubt the defense would have been, it has nothing to do with Lily being a woman. She just doesn't do the job as well as the men. But now she's worked there over a dozen years and she's gotten good performance ratings. So they can no longer have the defense that she doesn't do the job as well. They've already rated her superior to some of the men who were making more than she was. So she has a winnable case, and then the court says, but she sued too late. So I wrote a dissent explaining all that, and then I had at the bottom line, the ball is now in Congress's court to correct the error into which my colleagues have fallen. And inside of 2 years, we had the Lilly Ledbetter Fair Pay Act. It was a wonderful case because the court's wrong decision engaged the public, and the law was, it was the first law that President Obama signed when he took office.
Okay, in the back, Olivia, I think.
I think you've beautifully evoked the solidarity that can exist between women over the course of your career. But I'm just wondering now, as more and more women ascend into an elite position and are therefore complicit to some degree in the oppression of those women at the very bottom, to what extent can the same solidarity exist between women today?
To what extent?
Can solidarity exist between women today when you take in the class factor?
Well, I'm hoping it's reviving in this current generation. You know, from my time, the 70s, the women's movement was coming alive all over the world, some places to a greater extent than others, but the UN had declared International Women's Year. So the solidarity, the being part of a movement was very big in the 70s, then sort of died down. But now I see my granddaughter's generation, and these women seem to be fired up, these young women, more than the generation just ahead of them. At least that's my hope.
Daniela.
I was wondering, as the Lilly Ledbetter case was mentioned, if there are any of your other dissents that you think will have an impact on the legal or perhaps legislative developments in the future.
I think the dissent that I mentioned first, Shelby County, called public attention to the mistake that the court had made, and people have seen now the effort in some states, some localities, to restrict access to the polls by requiring voter IDs, by shortening the hours that people can exercise the franchise, closing the polling stations on weekends, all kinds of barriers that didn't exist while the 1965 Voting Rights Act was in force, because the key to that law was that states that had a history of disenfranchising African Americans could not make any change in their voting laws without getting the approval either of the Department of Justice or of a 3-judge district court in the District of Columbia. So that was an effective check on states trying to exclude African Americans from the polls. Once that check was declared invalid, the laws that the Department of Justice had turned down appeared, and there was no way to stop them, short of a very long litigation process. So that's where we are now. I think my dissent in the Hobby Lobby case will eventually become the prevailing view. For those who don't know, it was a challenge by a company owned by people who had a deep religious conviction against certain kinds of contraception. They had a large workforce. They said, we're not going to pay for health insurance coverage for contraceptives. The argument on the other side was, well, that's fine, whatever you want to believe is fine, you can believe it, but your workforce includes many, many women who do not share your view, and the law says we are entitled to have contraceptive coverage. The court said that the freedom of religion of the employers had to be respected, and therefore the employers did not have to provide contraceptive coverage. I explained why I thought that was a wrong decision, and I think someday that will be appreciated. It's one thing what you want to believe, and you have every right in the world to keep the government from stopping you from exercising your religion, but you don't have the right to foist your beliefs on people who don't share them. So that was the Hobby Lobby case.
Elena.
So you're talking about your favorite dissent in favor of gender equality. I was wondering, what is your favorite decision in favor of gender equality in the time you sat at the court?
Most people would probably say my opinion for the court in the Virginia Military Institute case. This is a state institution. It's a military institute, but only 15% of the graduates go to the military. Most of them go into commerce. There was nothing, the state of Virginia did not maintain anything in any opportunity for women of that character. So the court held a state cannot provide an opportunity for one sex only. So the state of Virginia had a choice, either admit qualified women or close up shop. Now I must say that the faculty at VMI was overwhelmingly in favor of the admission of women because they saw it as a way of upgrading the caliber of their students. Something else that was significant was that the plaintiff was not a young woman who had been denied admission. It was the United States government. And it wasn't that many years ago when we were litigating against the government because the military academies, West Point, Annapolis, Air Force Academy, didn't admit women. So the government, midway through that lawsuit, decided it's better to switch than to fight. They began admitting women, and by the time of the VMI case, women had been attending the military academies for over 10 years. Made it an easy case, I think. But one of my favorite cases is it's not my majority cases is not that well known. It's called MLB is the name. It was a woman who was charged with being a neglectful parent, so this was a proceeding to deprive her of parental rights. She lost in the court of first instance. In order to appeal, she had to purchase a transcript of the proceeding in the first instance. she didn't have the money to do that. The decisions below were, this is a civil case. Yes, the government has to provide defense for a criminal defendant and pay the expenses, but not in a civil case. And in my opinion, says we don't, you really can't, the lines are not that clear. That is, this, you type this as civil, but depriving a woman of her parental status is far more devastating to her than, say, a week in jail. And so the court came to see that and said it's unconstitutional to preclude this woman from having an appeal simply because she couldn't pay for the transcript.
Mm-hmm. Yes.
Hello, my name is Elise. I'm a second-year researcher here at the EUI, and when people ask me, so what do you do here at the EUI, sometimes I will answer, I write a PhD about law, and sometimes I will answer, I write a PhD about feminist legal theory. And I would like to hear about you. Do you consider yourself as a feminist? Or because this word is both sometimes controversial, sometimes it is fashion to define yourself as a feminist. So I would like, because I think I haven't heard or read you using this term, so maybe I misunderstood.
If you haven't heard it, you'll hear it now. I am a feminist. It is true, in the United States, in some quarters, a feminist is considered the F word. But what does it mean? It means you think that society should encompass, should embrace all people, women as well as men. That women should have a fair chance to do whatever their God-given talent enables them to do, and they shouldn't be held back by artificial barriers. That's all it is. So most men I know would count themselves feminists. Certainly my spouse did.
So maybe I will ask you the last question then. As our researchers move on in making choices for their lives and careers, what would be that one single and most precious piece of wisdom and advice you would want to share with them?
A single piece of advice? Yes. Well, I can only say in my own life, I have gotten tremendous satisfaction from doing things for which I was not paid. I think if you're a professional of any kind, you have an obligation to try to make things better for your local community. If you have a passion about an issue, it doesn't matter whether it's trying to root out racism or ending sex-based discrimination or preserving the environment, whatever it is, in addition to whatever your work is, do something that will help repair tears in the communities in which you live, that will make things a little better for other people.
Thank you so much, Justice Ginsburg.
Thank you.